Hey guys, it's Anthony Bandiero here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you another roadside chat from the studio. Okay, so this question comes from an officer from Ohio, and the question essentially is, can officers enter a room to seize evidence observed during a landlord apartment inspection? Hopefully that makes sense. Let me give you some context. So the officer says, all right, there's a landlord that asks officers to stand by while they do in a safety inspection on an apartment of a person. The tenant is known to maybe engage in narcotics trafficking. Maybe this person has given the landlord a hard time in the past, and they just want, almost like a civil standby. All right, so that's our first thing. Now, while the landlord is in the apartment, the landlord leaves the door open. The officers observe evidence on a kitchen table. They want to know, can we go into the apartment and seize the evidence? The answer is going to depend on whether or not somebody is in the apartment, and it's going to depend on whether the landlord is acting as an agent of police when they conduct their business. All right, let's walk through it step by step. This is a very common question, actually, but it's a question that has a few components. Number one, can officers even stand by under the scenario? Well, the answer is yes, because this is landlords simply asking police to be around just in case something happens is not a Fourth Amendment search, right? It's private action. As long as the police are not encouraging, directing, participating in the private conduct, we should be okay. Now, officers are going to want to be very, very careful about saying anything to the landlord like, hey, while you're in there, keep that door open. Now, if there's a legitimate safety issue, let's say people are in the apartment, I think that's reasonable. But if we know nobody is in the apartment and the cops are saying it in order to look around, that activity, in my view, is converting the landlord into a government agent, because you are telling them to do something that you could not do. You could not keep a door open just to look inside someone's apartment without any call for service, why you're supposed to be there, and so forth, right? Some kind of exigency. So therefore, if the landlord does it, so be it. That's private action. But be careful about you saying it unless you have a legitimate safety need. And even then, the court may still suppress it, but at least you have a fighting chance. That's the first thing. So the first question, are we there as just bystanders, or are we there involved in it? Hopefully you're not involved in it. Let the landlord do what they're going to do. You stay outside and mind your own business unless something goes on. Okay. The next step, the officers then, because the door happens to be open because the landlord left it open, the officers see plain view evidence on the kitchen table, drugs, some other evidence and so forth. Can the officers go in there and seize it? Well, the default answer is absolutely not. The cops have no authority to enter an apartment to seize evidence without some form of exigency, emergency, urgency. And the landlord cannot give you any consent to enter that apartment. Just because they're allowed to enter the apartment doesn't mean that you can, right? That just makes sense. They are there under a contractual obligation. They are a contractual authority and safety inspections and so forth, right? So that's none of your business. That's a private search. It doesn't really matter. Constitutionally, it's not of constitutional concern. Can you ask the landlord to recover the evidence? Absolutely not. You cannot convert that landlord into a government agent. You could not do it. Therefore, the landlord cannot do it on your behalf. Therefore, if you see evidence inside the apartment, what you're supposed to do is, if the apartment is empty, get the landlord out, seal it from the outside, go get your warrant. Now, if the suspect is on premises and he knows that you saw the evidence and the evidence is readily destructible, right? It can be destroyed or flushed down the toilet and so forth, then it looks to me And if you believe that he's going to destroy the evidence before you can get the warrant, then you probably have imminent destruction of evidence. But I would try other things first. I would try to tell him, hey, come out of here. Let's say the occupant, hey, come out, talk to us. Then you can arrest him, detain him, whatever you're going to do. I would try that. It seems reasonable to do a sweep to make sure nobody else is in there while you're getting your warrant. But I would also like to know that what this is all about. I hope this is not over, in my personal opinion, a joint, right? This should be pretty serious because the court is going to criticize and maybe just critical of the whole thing. They're going to make sure that this is not just a ruse to see in people's apartments, that you're not in cahoots with this landlord. How many times have you done it before? What was the conversation and so forth, right? Was this a legitimate issue with this tenant? That's the court's going to want to know that, just in my personal opinion. All right. So there's your answer. The default answer is absolutely not, unless you have exigency that occurs on the spot. And remember, you're not supposed to be creating exigency either, but merely being present shouldn't do it. That case, that idea was fairly established in a case called Kentucky versus King, U.S. Supreme Court. All right. Hopefully you understand what I'm saying here. If there's any confusion or you want some more clarification, reach out, put something in the comments and I'll clarify. All right. Look, do you want me to continue doing these? Are these moving the ball forward even an inch? Then all I ask is you hit the like button, subscribe to my channel, let your friends know. All right. If you do that, I will keep doing that. I will keep doing these, I want to help train cops. All right. All right. And also don't forget, I do free webinars every single week. Go to blue2gold.com. All right, guys, until next time, stay safe.
When it comes to legal training, we're the gold standard. Visit blue2gold.com or call 888-579-7796 today to purchase the Search and Seizure Survival Guide, register for a class, or learn how to bring our search and seizure training to your agency.